Question 1. In a high-stakes environment where multiple challenges arise in the interrogation of a high-profile suspect, law enforcement officers conduct a prolonged custodial interrogation without reading Miranda warnings. The suspect ultimately confesses to the crime. However, before trial, the defense moves to suppress the confession based on a violation of the suspect's Fifth Amendment rights. The prosecution argues that since the confession was voluntary, the suspect was not coerced. It should be admissible. How should the court rule on the admissibility of the confession? A. The confession is admissible because it was voluntary and not coerced. B. The confession is inadmissible because the suspect was in custody and was not informed of their Miranda rights. C. The confession is admissible because Miranda warnings are only required if the suspect explicitly asks for a lawyer. D. The confession is inadmissible only if the suspect later invoked their right to remain silent. Answer. B. The confession is inadmissible because the suspect was in custody and was not informed of their Miranda rights. Explanation. Under Miranda v. Arizona, 1966, suspects must be informed of their right to remain silent and their right to an attorney before a custodial interrogation begins. The Fifth Amendment protects against self-incrimination, and the failure to provide Miranda warnings renders any confession obtained during a custodial interrogation inadmissible in court. The Supreme Court has repeatedly held that Miranda warnings are a prerequisite to admissibility, not merely a factor in determining voluntariness. Option is incorrect because even if the confession was voluntary, it still violates the Miranda rule, making it inadmissible. The voluntariness standard applies separately from the requirement that Miranda warnings be given. Option C is incorrect because Miranda rights must be proactively given by law enforcement, even if the suspect does not explicitly ask for a lawyer. Option D is incorrect because a suspect does not need to invoke their right to silence for Miranda to apply. Warnings must be given automatically when person is in custody and subject to interrogation. Question 2. During a seamless transition where continuity must be maintained in law enforcement protocols, a police officer conducts a traffic stop for a minor speeding violation. While writing the ticket, the officer notices that the driver appears nervous and fidgety without reasonable suspicion of criminal activity. The officer extends the stop for an additional 15 minutes to allow a drug-sniffing dog to arrive. The dog alerts to the presence of narcotics, leading to the driver's arrest. The driver later challenges the search, arguing that it violated the Fourth Amendment. How should the court rule? A. The search was lawful because the dog's alert provided probable cause for the arrest. B. The search was unlawful because the officer extended the stop without reasonable suspicion. C. The search was lawful because minor delays in traffic stop are permissible if law enforcement suspects criminal activity. D. The search was unlawful because drug-sniffing dogs are not reliable evidence of probable cause. Answer. B. The search was unlawful because the officer extended the stop without reasonable suspicion. Explanation. Under Rodriguez v. United States 2015, law enforcement officers may not extend a traffic stop beyond the time needed to address the original violation unless they have independent reasonable suspicion of a separate crime. In this case, the officer detained the driver beyond the time required for the speeding violation without specific and articulable facts supporting reasonable suspicion. This violates the Fourth Amendment's protection against unreasonable searches and seizures. Option is incorrect because while drug-sniffing dogs alert can provide probable cause, the issue in this case is the unlawful extension of the stop. If the stop was prolonged without justification, any evidence obtained afterward is considered fruit of the poisonous tree and must be suppressed. Option C is incorrect because minor delays in traffic stops are only permissible if they relate to officer safety or the completion of the original purpose of the stop, not to conduct unrelated investigations. Option D is incorrect because courts have generally ruled that trained drug-sniffing dogs alert does provide probable cause, but that is irrelevant here since the stop itself was unlawfully prolonged. Question 3. When implementing new protocols in a shared environment, a state prosecutor seeks to retry a defendant who was previously acquitted of the same charges in state court. The prosecutor argues that new forensic evidence has emerged proving the defendant's guilt beyond a reasonable doubt. The defense asserts that retrying the defendant would violate the principle of double jeopardy. Under the Fifth Amendment's double jeopardy clause, which of the following best describes the correct legal outcome? A. The retrial is permitted because new forensic evidence has been discovered. B. The retrial is prohibited because it violates the double jeopardy clause. C. The retrial is permitted because the case is being prosecuted at the federal level rather than the state level. D. The retrial is permitted because the defendant waived their double jeopardy protections by testifying in their original trial. Answer B. The retrial is prohibited because it violates the double jeopardy clause. Explanation: the double jeopardy clause of the Fifth Amendment prohibits the government from retrying a defendant who has been acquitted of the same charges. The Supreme Court has held in Ash v. Swenson 1970 that once a defendant is acquitted, the prosecution cannot attempt to relitigate the same issue in a subsequent trial, even if new evidence emerges. Protection against double jeopardy ensures that the government does not repeatedly try a person until they obtain a conviction, which would undermine the finality of acquittals and expose defendants to unfair harassment. Option is incorrect because the discovery of new evidence does not override the constitutional protection against double jeopardy. Once a defendant is acquitted, the government has no opportunity to retry them, even with new evidence. Option C is incorrect because while the separate sovereigns doctrine allows both state and federal governments to prosecute for the same conduct, this case involves a state attempting to retry a defendant acquitted in the same jurisdiction, which is unconstitutional. Option D is incorrect because testifying in one's own defense does not waive the right against double jeopardy. The Fifth Amendment provides absolute protection from being retried for the same offense. Question 4. In a high-stakes environment where multiple challenges arise in handling electronic surveillance evidence, a law enforcement agency conducts a warrantless wiretap on a suspected organized crime syndicate. Over several months, the agency records hundreds of conversations implicating multiple individuals in conspiracy, drug trafficking, and money laundering. Trial defense attorneys challenge the admissibility of the wiretap evidence, arguing that the government violated the Fourth Amendment. Prosecutors argue that the surveillance falls under a national security exception and is necessary for public safety. Given Supreme Court precedents, which of the following most legally sound ruling on the admissibility of the wiretap evidence? A. The evidence is admissible because national security concerns override individual Fourth Amendment protections, making warrantless wiretaps lawful. B. The evidence is inadmissible because the Fourth Amendment generally requires a warrant for wiretaps and no valid exception applies in this case. C. The evidence is admissible because the conversations were recorded in a public setting where the individuals had no reasonable expectation of privacy. D. Evidence is inadmissible because law enforcement agencies are always prohibited from conducting electronic surveillance without a warrant, regardless of circumstances. Answer B. The evidence is inadmissible because the Fourth Amendment generally requires a warrant for wiretaps and no valid exception applies in this case. Explanation: the Supreme Court has consistently held that wiretapping constitutes a search under the Fourth Amendment, requiring a valid warrant. The Foreign Intelligence Surveillance Act, FISA, provides a limited exception for national security-related surveillance, but it applies primarily to foreign, not domestic criminal investigations. In Katz v. United States, 1967, the court ruled that individuals had a reasonable expectation of privacy in their conversations, making warrantless wiretaps unconstitutional unless they meet a recognized exception. The public safety exception, New York v. Qualls, 1984, applies to immediate threat, not prolonged surveillance. Option is incorrect because national security concerns do not automatically justify warrantless searches in domestic criminal cases. Option C is incorrect because the recordings were not obtained in a public setting but through a wiretap. Option D is overly broad, as there are limited exceptions where warrantless surveillance may be permissible. Question 5. During a comprehensive review of a process that needs improvement, a defendant who has been held in pretrial detention for over 2 years without a trial argues that his Sixth Amendment right to a speedy trial has been violated. Prosecutors claim that the delay was necessary due to ongoing witness unavailability and complex evidentiary issues. The defendant's motion to dismiss the charges based on the violation is now before court. Under Supreme Court precedent, how should the court rule? A. Grant the motion because a delay of more than 1 year is automatically considered a violation of the Sixth Amendment right to a speedy trial. B. Deny the motion because delays caused by witness issues and complex evidence are justified and do not count towards speedy trial violations. C. Grant the motion if the delay is found to be unreasonable based on factors such as length, reason, assertion of the right, and prejudice suffered by the defendant. D. Deny the motion because the government has discretion in bringing cases to trial, and there is no strict time limit for pre-trial detention. Answer: C. Grant the motion if the delay is found to be unreasonable based on factors such as length, reason, assertion of the right, and prejudice suffered by the defendant. Explanation: The Supreme Court in Barker v. Winger 1972 established a four-factor test to determine whether a Sixth Amendment speedy trial violation has occurred. 1. The length of the delay. 2. The reason for the delay. 3. Whether the defendant asserted their right, and whether the defendant suffered prejudice due to the delay. A 2-year delay is significant, and if the delay is due to the prosecution's negligence rather than unavoidable circumstances, dismissal may be warranted. Option is incorrect because there is no automatic threshold for a speedy trial violation. Option B is incorrect because not all delays caused by evidentiary issues are justified. It depends on the specific circumstances. Option D is incorrect because the government does not have unlimited discretion in delaying trials, and excessive delays can violate constitutional rights. Question 6. While investigating a complicated issue between different jurisdictions, law enforcement officers in one state arrest a suspect and seize evidence without obtaining a warrant. The officers then transfer the suspect and the evidence to another state where different laws apply. The defense argues that the seizure violated the Fourth Amendment, while the prosecution asserts that the transfer of the case to a different jurisdiction makes the original seat irrelevant. Which legal principle best applies to this situation? A. The exclusionary rule applies and the evidence should be suppressed because the warrantless seizure violated the Fourth Amendment. B. The evidence is admissible because the transfer to another jurisdiction makes the original seizure legally relevant. C. The evidence is admissible if the officers acted in good faith and were unaware that a warrant was required. D. The evidence is inadmissible because once a suspect crosses state lines, prior procedural violation automatically invalidate all evidence. Answer A. The exclusionary rule applies and the evidence should be suppressed because the warrantless seizure violated the Fourth Amendment. Explanation: The exclusionary rule, Mapp v. Ohio, 1961, prevents the use of illegally obtained evidence in court even if the case is transferred to another jurisdiction. The fruit of the poisonous tree doctrine, Silverthorne Lumber Company v. United States, 1920, further extends this rule. Any evidence derived from the illegal search inadmissible. Option B is incorrect because changing jurisdictions does not cure a Fourth Amendment violation. Option C is incorrect because the good faith exception, United States v. Leon 1984, applies only when officers rely on a facially valid warrant, not when they fail to obtain one. Option D is incorrect because crossing state lines does not automatically invalidate evidence. Each jurisdiction still applies constitutional principles to evaluate admissibility. Question 7. During a major transformation where existing methods of police interrogation are being re-evaluated, a suspect is interrogated for several hours without being given a Miranda warning. The suspect eventually confesses. Later, the officers realize their mistake, provide the Miranda warning, and obtain a second confession. At trial, the defense moves to suppress both confessions. Under established criminal procedure doctrine, how should the court rule? They admit both confessions because Miranda warnings are only required for custodial interrogations. B. Suppress both confessions because the second confession is tainted by the first. C. Admit only the second confession because the Miranda warning was eventually provided. D. Suppress the first confession but admit the second if it was voluntary and uncoerced. Correct answer: D. Suppress the first confession but admit the second if it was voluntary and uncoerced. Explanation: Under Oregon v. Belstead, 1985, an initial failure to administer Miranda warnings does not necessarily render a subsequent properly Mirandized confession inadmissible. The key factor is whether the second confession was voluntary and untainted by coercion. However, in cases where law enforcement deliberately uses a question first, Mirandize later strategy, Missouri v. Sabat, 2004, the second confession may also be suppressed. Courts can factors such as the time elapsed between confessions, whether Miranda warnings were fully understood, and whether the second confession was the product of free will. Question 8. In a high-stakes environment where multiple challenges arise in law enforcement practices, officers receive an anonymous tip that drugs are being stored in the suspect's home. Without obtaining warrant, they enter the home and seize narcotics. The prosecution argues that the search was justified under the exigent circumstances doctrine. Which factor is most critical in determining whether the warrantless search is lawful? A. The seriousness of the crime being investigated. B. Whether the officers had probable cause before entry. C. Whether waiting for warrant would have led to the destruction of evidence. D. The reliability of the anonymous tip. Answer: C. Whether waiting for a warrant would have led to the destruction of evidence. Explanation: under the exigent circumstances doctrine, warrantless searches are permissible if immediate action is necessary to prevent physical harm, the destruction of evidence, or the escape of a suspect. Kentucky v. King 2011. However, mere suspicion or the severity of the crime alone does not justify a warrantless search. Mincy v. Arizona 1978. The prosecution must prove that officers had an objectively reasonable belief that evidence would be lost if they delayed. If the officers created the exigency themselves, the search is likely unconstitutional. Question 9. While investigating a complicated issue between different state jurisdictions, a federal agent conducts a warrantless GPS tracking of a suspect's vehicle over several weeks without obtaining judicial approval. The defense moves to suppress the evidence, arguing Fourth Amendment violation. How should the court rule? A. Admit the evidence because vehicles have reduced expectation of privacy. B. Suppress the evidence because warrantless prolonged GPS tracking is unconstitutional. C. Admit the evidence if the vehicle was parked in public space. D. Suppress the evidence only if the tracking exceeded 30 days. Answer: B. Suppress the evidence because warrantless prolonged GPS tracking is unconstitutional. Explanation: in United States v. Jones 2012, the Supreme Court held that placing a Dursus tracker on a suspect's vehicle constitutes a search under the Fourth Amendment. While individuals have lower expectation of privacy in their vehicles. California v. Carney 1985. Prolonged GPS tracking without warrant violate Fourth Amendment. Courts distinguish between short-term visual surveillance, which is permissible, and long-term GPS monitoring, which requires judicial authorization due to its invasive nature. Question 10. During a comprehensive review of a process that needs improvement in pretrial procedures, a defendant is held in pretrial detention for an extended period without a trial. The defense argues a violation of the defendant's right to speedy trial. Which of the following factors is least relevant in determining whether the delay was unconstitutional? A. The length of the delay. B. The reason for the delay. C. The defendant's assertion of the right. D. The complexity of the legal arguments in the case. Answer: D. The complexity of the legal arguments in the case. Explanation: under the Speedy Trial Clause of the Sixth Amendment, courts evaluate four factors from Barker v. Wingo 1972. The length of the delay. Delays exceeding 1 year are presumptively prejudicial. The reason for the delay. Deliberate attempts to hinder the defense are unconstitutional. The defendant's assertion of their right failing to demand speedy trial weakens the claim. Prejudice to the defendant, such as impaired defense, anxiety, or prolonged incarceration. Legal complexity is not a determining factor, as due process cannot be compromised due to procedural difficulties. Question 11. In a situation where formal requirements conflict with practical enforcement, officers arrest a suspect for a misdemeanor committed outside their presence. The officers had no warrant but received reliable third-party information. The suspect challenges the arrest as unconstitutional. How should the court rule? A. The arrest is unconstitutional because misdemeanor arrests require a warrant. B. The arrest is constitutional if the officers had probable cause. C. The arrest is unconstitutional unless the officers directly observed the crime. D. The arrest is only valid if exigent circumstances existed. Answer: B. The arrest is constitutional if the officers had probable cause. Explanation: while common law traditionally required officers to witness a misdemeanor before making an arrest, modern courts allow warrantless arrests based on probable cause. At Alta v. City of Lago Vista 2001. The Fourth Amendment does not categorically prohibit warrantless arrests for misdemeanors committed outside an officer's presence if probable cause exists. However, some states impose stricter requirements than the federal standard. Question 12. During an emergency response where multiple areas are impacted, police arrest a suspect and conduct a thorough search of their smartphone without a warrant. The prosecution argues that the search was lawful as a search incident to arrest. Is the search constitutional? A. Yes, because searches incident to arrest allow officers to examine any items in possession. B. No, because a warrant is required to search digital data on a smartphone. C. Yes, if the phone was unlocked at the time of arrest. D. No, unless exigent circumstances justified immediate access. Answer B. No, because a warrant is required to search digital data on a smartphone. Explanation. Under Riley v. California, 2014, the Supreme Court ruled that searches incident to arrest do not justify warrantless searches of digital data on smartphones, unlike physical objects. Smartphones contain vast amounts of private information, triggering heightened Fourth Amendment protections. Officers must obtain a search warrant unless exigent circumstances apply. Question 13. When implementing backup procedures across various law enforcement agencies, a police department develops a policy requiring officers to take DNA swabs from all felony arrestees without a warrant. A suspect challenges this practice. What is the most relevant Supreme Court precedent? A. Maryland v. King 2013. B. Katz v. United States 1967. C. Terry v. Ohio 1968. D. Illinois v. Gates 1983. Answer A. Maryland v. King 2013. Explanation. In Maryland v. King 2013, the Supreme Court upheld the collection of DNA from felony arrestees as a reasonable booking procedure under the Fourth Amendment. The court likened DNA collection to fingerprinting and photographing, but emphasized that such searches must be justified by a legitimate government interest, such as identifying suspects and solving crimes. Question 14. In a case where multiple parties have different objectives, law enforcement executes a search warrant at a suspect's residence. The officer sees evidence unrelated to the warrant but in plain view. The suspect moves to suppress the evidence. Under the plain view doctrine, which factor is most critical in determining whether the seizure is lawful? A. Whether the officers were lawfully present. B. Whether the evidence was related to the original warrant. C. Whether the officers had time to obtain new warrant. D. Whether the suspect consented to the search. Answer A. Whether the officers were lawfully present. Explanation. Under the plain view doctrine, Coolidge v. New Hampshire, 1971, officers may seize evidence without a warrant if they are lawfully present in the area where the evidence is found. The incriminating nature of the evidence is immediately apparent. They discover the evidence inadvertently. No pretextual searches. If officers were conducting a lawful search and encountered contraband or evidence of a crime in plain view, its seizure is constitutional. Question 15. During a major transformation where existing methods of identification are questioned, a witness selects a suspect from a one-person show-up identification. The suspect argues that the identification violated due process. Which factor is most relevant in determining admissibility? A. The witness's certainty in the identification. B. Whether the identification procedure was unduly suggestive. C. The time elapsed between the crime and identification. D. The suspect's criminal history. Answer B. Whether the identification procedure was unduly suggestive. Explanation. Under Neal v. Biggers 1972 and Manson v. Brathwaite 1977, courts examine whether an identification procedure was unnecessarily suggestive and likely to lead to misidentification. Show-up identifications carry a higher risk of suggestiveness, but courts may allow them if they occur shortly after a crime and under exigent circumstances. Question 16. In a multi-location scenario where consistency requirements must be met, a defendant is charged with multiple crimes in different jurisdictions. The defense argues that simultaneous prosecutions violate double jeopardy. Which principle applies? A. The Blockburger test. B. The separate sovereigns doctrine. C. The fruit of the poisonous tree doctrine. D. The standing requirement. Answer B. The separate sovereigns doctrine. Explanation. Under the separate sovereigns doctrine, Gamble v. United States 2019, the double jeopardy clause does not prohibit separate prosecutions by different sovereign entities, e.g., state and federal governments, for the same conduct. However, within the same jurisdiction, courts apply the Blockburger test to determine whether multiple charges constitute the same offense. Question 17. While examining inconsistencies across various units in law enforcement, a suspect's coerced confession leads to the discovery of physical evidence. The prosecution argues that the physical evidence should still be admissible. Which doctrine applies? A. The independent source doctrine. B. The inevitable discovery doctrine. C. The fruit of the poisonous tree doctrine. D. The good faith exception. Answer C. The fruit of the poisonous tree doctrine. Explanation. Under Wongsun v. United States, 1973, evidence obtained through unconstitutional methods is inadmissible as fruit of the poisonous tree. However, exceptions exist if the evidence was discovered through an independent source or inevitably would have been found. Nix v. Williams, 1984. Question 18. During a seamless transition where continuity must be maintained, police use a confidential informant to conduct a controlled drug buy. The suspect argues entrapment. Which factor is most relevant in determining whether entrapment occurred? A. The suspect's predisposition to commit the crime. B. The reliability of the informant. C. Whether the suspect was aware of the law. D. The amount of drugs involved. Answer A. The suspect's predisposition to commit the crime. Explanation. Under Sorrells v. United States, 1932, and Jacobson v. United States, 1992, entrapment occurs if law enforcement induces crime that the defendant was not otherwise predisposed to commit. Courts examine the suspect's past criminal behavior, willingness to engage in the crime, and interactions with the informant. Question 19. During a comprehensive review of a process that needs improvement, a court examines a defendant's claim that police violated Miranda rights by continuing questioning after an ambiguous request for counsel. What is the correct legal standard for determining whether questioning should stop? A. Police must immediately stop questioning if the defendant mentions an attorney in any context. B. Police may continue questioning unless the request for counsel is clear and unequivocal. C. Police must clarify whether the defendant actually wants lawyer before proceeding. D. The defendant must explicitly refuse to waive Miranda rights for questioning to stop. Answer. B. Police may continue questioning unless the request for counsel is clear and unequivocal. Explanation. Under Davis v. United States, 1994, police are not required to stop questioning unless a suspect's request for an attorney is unambiguous and unequivocal. If suspect says something vague like, "Maybe I should talk to lawyer," officers may continue questioning without seeking clarification. Question 20. When implementing new protocols in a shared environment, law enforcement sets up a Dewey checkpoint and detains drivers for brief questioning. A driver challenges the stop as unconstitutional. Which Supreme Court case is most relevant? A. Terry v. Ohio, 1968. B. Michigan Department of State Police v. Sitz, 1990. C. Delaware v. Prass, 1979. D. Indianapolis v. Edmond, 2000. Answer. B. Michigan Department of State Police v. Sitz, 1990. Explanation. In Michigan Department of State Police v. Sitz, 1990, the Supreme Court upheld Dewey checkpoints as constitutional under the Fourth Amendment, ruling that the government's interest in preventing drunk driving outweighs the minimal intrusion on drivers. However, in Indianapolis v. Edmond, 2000, the court ruled that checkpoints with the primary purpose of general crime control, e.g. drug detection, are unconstitutional. Question 21. While investigating a complicated issue between different agencies, law enforcement obtains evidence through an unconstitutional search but later secures the same evidence through a valid warrant. The prosecution seeks to admit the evidence. Which doctrine applies? A. The good faith exception. B. The independent source doctrine. C. The fruit of the poisonous tree doctrine. D. The standing requirement. Answer. B. The independent source doctrine. Explanation. Under Murray v. United States, 1988, the independent source doctrine allows evidence obtained illegally to be admitted if it is later acquired through a separate lawful means. If officers obtain a valid warrant based on untainted evidence, the prior illegality does not require suppression. Question 22. In a situation where resource allocation becomes critical, a city implements an automated red light camera system that issues fines without officer involvement. A driver challenges the system on due process grounds. Which factor is most relevant to the system's constitutionality? A. Whether the driver was given fair opportunity to contest the citation. B. Whether an officer personally witnessed the violation. C. Whether other drivers received similar fines. D. Whether the fine was excessive under the Eighth Amendment. Answer. A. Whether the driver was given a fair opportunity to contest the citation. Explanation. Automated enforcement systems are generally constitutional as long as defendants are provided due process, including the right to contest the ticket. Matthews v. Eldridge, 1976. Courts have upheld red light and speed camera fines if the process allows drivers to challenge the citation before an impartial authority. Question 23. While updating traditional approaches where interconnections exist between agencies, police officers mistakenly execute a search warrant at the wrong address. The resident sue, alleging a Fourth Amendment violation. What is the key legal issue? A. Whether officers acted in good faith and the mistake was reasonable. B. Whether the warrant listed the wrong address. C. Whether officers used excessive force during the raid. D. Whether the residents had a criminal record. Answer A. Whether officers acted in good faith and the mistake was reasonable. Explanation. Under Maryland v. Garrison, 1987, a search warrant executed at the wrong address does not violate the Fourth Amendment if officers acted in good faith and the mistake was reasonable. However, if officers were reckless or negligent in verifying the address, the search may be unconstitutional. Question 24. During an emergency response where multiple areas are impacted, police use thermal imaging to detect excessive heat in a suspect's home, leading to search warrant. The suspect challenges the evidence. Which case is most relevant? A. Kilo v. United States, 2001. B. United States v. Jones, 2012. C. Florida v. Jardines, 2013. D. Katz v. United States, 1967. Answer A. Kilo v. United States, 2001. Explanation. In Kilo v. United States, 2001, the Supreme Court ruled that using thermal imaging to detect heat patterns inside a home constitutes a search under the Fourth Amendment and requires a warrant. The court reasoned that technology not commonly available to the public cannot be used to intrude on a person's reasonable expectation of privacy. Question 25. When scaling up operations that experience significant legal challenges, a city enforces a ban on panhandling in public spaces. Homeless individuals challenge the law on First Amendment grounds. What is the most likely outcome? A. The law is unconstitutional because panhandling is protected speech. B. The law is constitutional if it only applies to aggressive panhandling. C. The law is constitutional if it applies to all speech equally. D. The law is unconstitutional because it violates equal protection. Answer A. The law is unconstitutional because panhandling is protected speech. Explanation. Courts have consistently ruled that panhandling is a form of speech protected under the First Amendment. Read v. Town of Gilbert, 2015. Total bans on panhandling in public spaces are typically struck down as content-based restrictions on speech. However, cities may regulate aggressive panhandling or limit solicitation in specific areas. Question 26. During a seamless transition where continuity must be maintained, police track a suspect's real-time location using cell phone data without warrant. The suspect moves to suppress the evidence. Which Supreme Court case applies? A. Carpenter v. United States, 2018. B. Riley v. California, 2014. C. United States v. Jones, 2012. D. Smith v. Maryland, 1979. Answer A. Carpenter v. United States, 2018. Explanation. In Carpenter v. United States, 2018, the Supreme Court ruled that police must obtain a warrant to access historical cell site location information (CSLI) because individuals have a reasonable expectation of privacy in their long-term location data. This decision significantly limited the third-party doctrine, which previously allowed police to collect data without a warrant. Question 27. While managing a hybrid approach where timing issues impact legal procedures, a suspect is held in custody for 72 hours without a judicial hearing. The suspect challenges this detention. What rule applies? A. The suspect must be brought before a judge within 48 hours of arrest. B. The suspect must be released if no charges are filed within 24 hours. C. The suspect must be given a preliminary hearing within 7 days. D. The suspect can be held indefinitely if law enforcement is investigating. Answer A. The suspect must be brought before a judge within 48 hours of arrest. Explanation. Under County of Riverside v. McLaughlin, 1991, the Fourth Amendment requires suspects to be brought before a magistrate within 48 hours for a probable cause determination. Detentions exceeding this time frame without a hearing are presumptively unconstitutional. Question 28. While analyzing the root causes of sequential problems in search and seizure procedures, police officers stop a vehicle for a minor traffic violation. During the stop, they extend the encounter for an additional 20 minutes to bring a drug-sniffing dog without reasonable suspicion of drug-related activity. The dog alerts to narcotics, leading to an arrest. The defendant moves to suppress the evidence. How should the court rule? A. The evidence is admissible because the drug-sniffing dog provided probable cause. B. The evidence is inadmissible because extending the stop without reasonable suspicion violated the Fourth Amendment. C. The evidence is admissible because the dog's alert created an independent basis for the search. D. The evidence is inadmissible because all traffic stops exceeding 15 minutes are unconstitutional. Answer: B. The evidence is inadmissible because extending the stop without reasonable suspicion violated the Fourth Amendment. Explanation: in Rodriguez v. United States 2015, the Supreme Court held that officers may not prolong a traffic stop beyond the time needed to address the initial reason for the stop unless they have independent reasonable suspicion of criminal activity. Even if the dog's alert provided probable cause, the unconstitutional extension of the stop taints the evidence, making it inadmissible. Option is incorrect because the drug dog's alert cannot retroactively justify an illegal detention. Option C is incorrect because the alert does not cure the unlawful extension of the stop. Option D is incorrect because the court has not set fixed time limit, but instead focuses on whether the stop reasonably relates to its original purpose. Question 29. During a critical transition period where existing processes for plea bargains are being revised, a defendant claims they were coerced into accepting a plea deal due to the threat of a harsher sentence if they went to trial. The prosecutor denies coercion and argues that offering a more lenient sentence in exchange for a guilty plea is lawful. What is the correct legal standard in determining whether the plea is voluntary? A. The plea is voluntary if the defendant signed a written plea agreement. B. The plea is voluntary if the defendant understood the rights they waived and the consequences. C. The plea is involuntary if the prosecutor offered any incentive to plead guilty. D. The plea is involuntary if the defendant would not have pled guilty without the prosecutor's threat. Answer: B. The plea is voluntary if the defendant understood the rights they waived and the consequences. Explanation: under Brady v. United States 1970, a guilty plea is constitutionally valid if it is known, voluntary, and intelligent. This means the defendant must understand the nature of the charges, knowingly waive their rights, e.g. trial confrontation and self-incrimination, accept the plea without unlawful coercion. Prosecutors may offer leniency to encourage guilty pleas, but they cannot use improper threats to compel a plea. As long as the defendant understood the terms and made the decision freely, the plea is valid. Option is incorrect because a written plea alone does not prove voluntariness. Option C is incorrect because offering plea incentives is constitutional if done properly. Option D is incorrect because the existence of leverage alone does not amount to coercion. Question 30. In a high-stakes environment where multiple challenges arise during trial procedures, a defendant's attorney falls asleep repeatedly during the trial. The defendant argues ineffective assistance of counsel and seeks new trial. What is the most appropriate legal framework for evaluating this claim? A. Whether the attorney violated local ethical code. B. Whether the attorney's conduct fell below an objective standard of reasonableness and prejudiced the defendant. C. Whether the attorney's mistakes were intentional. D. Whether the attorney had substantial trial experience. Answer: B. Whether the attorney's conduct fell below an objective standard of reasonableness and prejudiced the defendant. Explanation: under Strickland v. Washington 1984, claims of ineffective assistance of counsel require the defendant prove two elements: deficient performance. The attorney's conduct fell below an objective standard of reasonableness under prevailing professional norms. Prejudice: there is reasonable probability that, but attorney's errors, the outcome of the trial would have been different. Severe lapses, like repeatedly falling asleep, can be presumptively prejudicial under United States v. Chronic 1984 if they amount to complete denial of counsel. Option is incorrect because an ethical violation does not automatically prove ineffective assistance under the Sixth Amendment. Option C is incorrect because intent is not required. Incompetence alone may suffice. Option D is incorrect because experience does not excuse inadequate performance.